There was a question asked earlier about the waiting time at Lismore there. What would be the average waiting time for cases to be heard in family law courts and family district courts?
I could provide an indication from the end-of-year results about the finalisation time, but listing times and finalisation times are slightly different. But
waiting times for families, would it be unrealistic to say about 3 years, that some are actually waiting to get their cases heard? 2 to 3 years?
I don't have the full statistics. I do have a figure which comes from the evaluation of end-of-year results for 16-17, and the median time to finalisation of an order in family law matters in the Circuit Court is 8.4 months. That's to finalisation. That's to the completion of the matter.
I think we need to be a little... Sorry, I didn't mean to interrupt. Please finish, and then I just want to make an observation. Are you finished?
Yes.
I think it's important when we're pursuing this matter, Senator Hanson, to keep in mind that the distinction between final hearings and interim hearings, a great many of the matters that come before the Family Court and the Federal Circuit Court are interim hearings, and quite often the interim arrangements and orders that are made end up being the final orders, because an interim arrangement having been made, the parties quite often either accommodate themselves to it or agree to variations to it, which then become part of a consent order. There are obviously interim hearings take place in a shorter time frame than final hearings.
I am well aware of that, but if it's not sorted out in an interim hearing, so then after that, then it could take 2 to 3 years for it to be heard, which puts a lot of stress on families waiting for their case to be heard.
Of course it does, and the government's very conscious of this. But the other thing, of course, to be borne in mind is the nature of the matters in dispute. Now, plainly, matters involving children are of a more immediate and sensitive nature, as a general rule, than property matters. You could have let us take well, it's not a hypothetical case. There are these cases happen not infrequently of separating spouses who have sorted out the children matters, or they may not have children because their children may be grown up, or they may not be have children at all, and they may be a wealthy couple who've got a lot of assets held in different structures, trusts and so on, and it might take a long while to sort out the complex property law issues in a case like that. But if there aren't children, if there are no children involved in the case, or the children's aspect is sorted out, and the couple are not under any particular financial stress, then it's basically a piece of commercial litigation about the way in which property is divided. So, there is a variety of different cases, and it's not always the case.
But
the 2 to 3 years is a remarkably long period of time, but it may be.
Let me ask you this question then. Do you believe that the courts are overloaded now with the number of cases and lack of judges?
I believe that I would like to have more judges.
All right.
I would like to have more judges. The Family Court, the Federal Circuit Court would like to have more judges, and it's a resourcing issue.
In that case, you have judges now. How many judges are actually on sick leave? And what is the average time for those judges being on sick leave?
Well, I'll take that on notice, Senator Hanson, so I can give you precise figures. But you're right when you identify that as being part of the problem, because I know that on the Federal Circuit Court there are several judges who are on sick leave, and the court is not running at 100% capacity for that reason.
is there a certain period of time that a judge can be on sick leave? I mean, say if they're on sick leave for about 6 months or 3 months or 6 months, that it's putting a lot of pressure on the courts.
Well,
what is what is being done about that to alleviate that pressure?
Look, Senator Hanson, you are dead right in identifying this as being part of the problem. Obviously, if you have a court running with several of its members not able to sit, that puts more pressure on other parts of the system. As to the specific rules about sick leave arrangements, I think it would be wiser for me to take that on notice and give you, to make sure the information I give you is accurate.
Is the government looking at appointing more registrars to alleviate the pressure on the judges and take on mentions, which is going to alleviate the pressures and the backlog of work?
Yes.
Workload.
Yes, we are, and more broadly, I mean, you'll be familiar, Senator Hanson, because I know you've taken a great interest in this area of the law, and I know that you've had a number of conversations, not just with me, but with my advisor, Dr. Cochrane, and I thank you for your input into our thinking about these issues. We are increasingly looking to extracurrial resolutions of these matters. That's why we are piloting the idea of parenting management conferences. Now, none of these cases are easy. There is no such thing as a good story in the family court. But what we are trying to do is achieve justice in circumstances of unhappiness. And almost certainly the most vexed issues in family proceedings are in relation to children, for obvious reasons. So the government is piloting a system of parenting management conferences so that these issues about parenting and access to children and so on and custody can be sorted out at the earliest possible stage of the proceedings. The other point I would make to you, Senator Hanson, is the government recently announced, as you know, that we are going to ask the Australian Law Reform Commission to have the first comprehensive review of the family law system since the Family Law Act came into operation on the 1st of July 1976. It's been amended many times in the last 41 years, but it has never been the subject of a comprehensive review. So the government is doing that. I have finalised the terms of reference, and we've identified the person who we want to lead that inquiry and to be appointed a full-time member of the Australian Law Reform Commission. We are close to finalising the identity of the 2 part-time commissioners who will assist her, and that comprehensive review of the family law system will look at those issues, among others.
And when do you think the earliest time that might be up and running? Will it be
up and roll? But well, before the end of this year.
I'm really pleased to hear that, and a lot of Australians will be very pleased to hear that, have an input on that. Just moving to another area, what expertise, knowledge and experience and qualifications did the courts put on psychologists that are appointed to do the petitioners in these cases?
Well, once again, Senator Hanson, that's a very good, very, very relevant question. One thing we know about the family law system is that lawyers do not have all the answers. The judges have to be legally qualified, but this is one area of law in which a variety of different professional skills are desirable for there to be the most appropriate outcome. And increasingly we engage members of professions other than the law, including psychologists, as you say, and indeed one of the terms of reference for the review of the family law system is to consider whether or not there is greater scope for the engagement of other professionals, including psychologists, in the disposition of cases.
Is it, if you have a family law court... If you have the family law court matter being heard in one court, is the psychologist to come from that state, or can they be appointed from any other state? And who does the appointment, and can the ICL appoint that psychologist?
Look, there's no particular rule about where the person comes from. There are guidelines or rules about the appointment of experts to advise the court, of course, but I don't. I'm prepared to stand corrected, but I don't believe that the locality within Australia of the expert, apart from obvious issues of convenience, is relevant.
Well, I'll just bring one case to your attention, is that case was in Townsville. The ICL appointed a psychologist from Hobart, Tasmania, who was a close associate and went to school with the ICL, ended up a biased case where the psychologist was not involved in watching the interaction between the father and the child, and made an assessment in that case, which was biased against the father.
Well, Senator Hanson, for reasons that you'll well understand, I'm not going to comment on.
But I'm just asking about psychologists.
I'm not going to comment on individual cases, but if you want to draw, if you want to write to me, or perhaps we can have a private meeting and you can explain that case, give me the particulars of that case privately, then I'll make an inquiry.
Thank you very much.